First of all, I have said it time and time again, I will not vote for anyone without compassion or empathy, and you hit the two attributes. Can you think of when you, some case that you worked on that impressed you the most about this nominee?
Sure. A few, but I think one that sticks out in my mind is the way that she defended and fought for victim rights in a child exploitation case. There was a question about restitution to a young girl that had been exploited and had her images of her being sexually assaulted put over the internet. There's a question about restitution, and Karin was dogged in her determination. She fought for that victim, fought for the restitution to make sure that victim would receive the restitution, argued it all the way up to the First Circuit when it was appealed, and won there. And I think that's who Karin is. She saw someone that was in need, and that money really helps that person. It helps them through all the things that they're going to need to try to get through as they try to get themselves back on track in an effective way.
Well, your testimony means a lot to me because I always look to the nominee, how much involvement they have in the court. And you said it all, that she cares about everyone that works in that court, to think of them and to show that gesture to give to them. That means a lot. I guess that's it here with the questions, but I thank you so much. Your testimony means a lot. Thank you.
Thank you for the opportunity.
Is there anyone here, not on the list, who would like to speak on behalf of this nominee?
Well, I do have to say.
You have to take a seat, please.
I'm happy to.
Just tell us your name and where you're from.
Yes, my name is Heidi Brugger.
You can take your
I'm
mask off.
Chief Justice of the Superior Court. It's an honor to see you all again. I don't usually stand before a microphone, but this is a little bit of a different situation. I rarely get to say anything about a friend and former colleague, and it is very easy for me to tell you all that I think Karin Bell would be a tremendous addition to the Superior Court, not for all of the reasons that they've given, which are all very true in my estimation, but because I know what it takes personally to be a good judge. I know the stress and the strain and the rewards and the responsibility of this job. And I know Karin very well, and I know that she can do it. And I know that we need her. So I urge you to confirm her.
Well, thank you for all your service. And how long has it been now?
10 years.
Wow. And I am the only one out of the 4 other members of the council here that have voted for you. And I'm so, were you there 10 years ago? Huh? Were you here 10 years ago?
Yes, I voted for.
Wow. Okay. So I stand corrected. I can't believe it's 10 years.
Yes or no vote?
It was a yes.
Oh, stop. That was 10 years. Okay,
I remember
Terry.
vividly.
Yeah, well, thank you for all your service and thank you for coming to speak. You were not on the witness list and we appreciate your testimony.
Thank you, Chief.
Is there anyone in opposition? Okay, having said that, now it's your turn to tell us about yourself.
Madam Chair, just before you start,
I'm sorry, Mary?
for the record, I had 2 conversations with you, one that was very lengthy. Vinnie Majorni, who I've known for 40 years, thinks the world of you. I can't stay. I broke a tooth a couple weeks ago at this hearing. And so I've got to go so that I can get.
Okay, so you do know the nominee.
I do know the nominee. I intend to vote for the nominee. And among the people who are in her corner is former Governor William Weld, who gave me a job.
No kidding.
So she's aces with me.
That means a lot. Thank you so much,
Thank you.
Councilor Hurley. Having said that, now it's your turn to make your presentation.
Thank you. Members of the Executive Council, I am incredibly humbled to be here today, but I'm also very excited to be here today to ask you for your confirmation to a position on the Superior Court. I'd like to thank Governor Baker and Lieutenant Governor Karen Polito for their nomination and for the confidence that they've placed in me. I'd like to thank Bob Ross And I want to especially thank Lauren Green Petrino, because she's given me invaluable assistance in preparing for and getting ready for this process.
Solid C plus.
Going with an A, or mid A plus, we're going with A plus. I'd like to thank the JNC and the Joint Bar for their diligent efforts to ensure that the most qualified candidates are put before this council. And last but not least, I want to thank all of you for the time that you've given me over the past few weeks, despite my nerves, for the time just being here today to meet my husband and to listen to my witnesses and to myself. I really appreciate it. I've introduced my husband, but I'm just going to tell you a little more about him. He's here to support me. He has been here to support me for 32 years, and I'm not going to make you do the math. I met him when I was 14 years old, and we started dating when I was 15 years old, and we never stopped. And he is going to cringe when I say this, and because he's going to think it's cheesy, but in fact, he is my soulmate. We together have 3 beautiful girls. Allison, who just turned 11 last week, who loves soccer and gymnastics, and she's fiercely competitive. Avery, who just turned 9 in January, loves figure skating, ballet, and reading. And then my 6-year-old, Ashley, who loves singing, reading, art, and any dog on the face of the earth. I wanted to have them here today to meet you all, but I think my 6-year-old at this point would be running around the room trying to sit in someone's lap. So I left them at home, and my husband's actually going to leave after my statement so that he can help get them through school. My children have taught me what life is all about. There's no question about that. They have taught me patience. They've taught me how important it is to listen. And they've really taught me about absolutely unconditional love. And what I hope to show them, one of the things I hope to show them, is that you can be a very present mom and still have a very impactful career serving the public. I want to take this opportunity to tell you just a little bit about myself that you're not going to get from my resume. I grew up on the eastern shore of Maryland in a small town called Easton. I was raised by my parents, Janet and Ken Smith, and I'm the oldest of 4. I have 2 sisters who are 2 of my best friends in the whole world. One is the mother of triplets, 10-year-old triplets, and the other is a nurse. My brother is also the father of 3. He's an engineer at a nuclear power plant. Growing up, there were many things that my parents taught me. I would say the 2 most important things were the importance of hard work and self-sacrifice. My mom took me to fill out an application for my first job when I was 14. I started my career as an ice cream scooper, and I have always worked at least one job since the age of 14. As a teenager, I spent some of my summers working the morning shift at the Burger King in the town where I grew up, and then I would walk across the 4-lane highway and I would do the afternoon shift at Popeye's Chicken and Biscuits. And then on the weekends, I would do shifts at Subway. My parents did not go to a 4-year college. My mom got her associate's degree. My dad did not. But they worked so hard to support their children and to give us opportunities to reach our goals that maybe they didn't have. My mom was a stay-at-home mom. Her life was taking care of her children. She brought in other children and ran sort of an informal daycare center sometimes to earn extra money and bred cats at one point. So there were always lots of children and animals in my house growing up. My dad worked as an accountant at a local car dealership in our town to support the family. When it came time for me to go to college, my parents were very supportive, but they didn't have a financial savings to assist me in that way. And I knew at that point in high school that I wanted to go to law school. I wanted to be a public servant. I thought I wanted to be a prosecutor, and eventually I hoped to be a judge, even that early in my life. And so I ended up making the decision to attend the University of Maryland, where I had a scholarship. When I got there, I took a job as a resident assistant so I could pay for my room and board. And I got a job waitressing at Plato's Diner, a Greek diner that was right off campus. I'm not going to go through all the jobs I told you, don't worry. But I learned from a very young person. And if you treat the people around you with kindness and with respect, you can achieve pretty much anything. I also mentioned my parents taught me self-sacrifice. I did not appreciate it at the time, but my parents devoted their younger lives to helping me to achieve my goals. I, as a child, loved figure skating, and I wanted to go to the Olympics. It was, and it still is, a very expensive sport, and not one that my family could. But my mom and my dad did what they could to make it work. My mom would drive our blue VW Rabbit an hour and a half at 4 o'clock in the morning to the University of Delaware twice a week for me while I was in elementary and middle school to try to give me some time, ice time, and to be able to take lessons. At one point, she actually contacted our local small town paper, and she asked a reporter to come out and to take a picture of me and do a story in the local paper to see if they could solicit donations or money to help me to achieve my dream of going to the Olympics. My dad was no different. Despite working hard, he and my mom did not have significant savings. But at one point, when I was getting ready to get married, my dad felt strongly about contributing to the wedding. And so, unbeknownst to me, he took out what money he did have from a life insurance policy to help me pay for my wedding. And he didn't tell me about it, and I didn't find out about it until years later when my mom told me, but that was my dad. It was more important to him that I was able to achieve something that was important to me than it was for him to do something for himself, in order to put money aside for later in his life. I will bring those traits, hard work, selflessness, and other traits like compassion and empathy to the Superior Court bench if I am fortunate enough to earn your confidence. As I've tried to demonstrate in my conversations with many of you, I do believe I possess the qualities necessary to be an exceptional Superior Court judge. First, I've been both a prosecutor and a defense attorney. I spent years at Goodwin Proctor before going to the United States Attorney's Office. And I spent years there representing an individual who, as I sit here today, I still believe was innocent of the charges the crimes that he was charged with. I fought zealously along with a team of other lawyers, first to convince the government not to charge him, and then when that failed, to prepare for trial. Ultimately, just weeks before trial, the team was able to secure a deferred prosecution agreement for the client, which was a great result. But I saw the toll that it took on my client. I watched him go from a strong, confident man to really a shell of his former self. When I left Goodwin, this client gave me a t-shirt, it had a fish on it, because he was a big fisherman and a hunter. And I framed the t-shirt and I put it on my wall when I first became a prosecutor. And it's been there for 14 years to remind me of the real implications that my job has on people's lives. And that my job was to do justice, and it was not to win. Second, as a litigator for the last 20 years, I know my way around a courtroom. I've handled hundreds of cases, civil and criminal, certainly more criminal than civil, but both, from start to finish. On the criminal side, I've handled hundreds of arraignments, bail hearings, motion hearings, evidentiary hearings, discovery motions, pleas, sentencings, trials, and appeals. I think I've handled almost every kind of criminal case. I've done violent crime, I've handled drug trafficking, I've handled white-collar offenses, and a number of very sensitive issues.
Bless.
Bless you. On the civil side, I've drafted complaints, interrogatories, handled depositions, and summary judgment motions. Throughout my practice, I've had a significant amount of time to develop my writing ability, which I know is important for the Superior Court. And so I believe that these litigation skills are going to help me in my transition from the federal court to the Superior Court. Third, I am motivated by a strong desire to do justice and to serve the public. It's motivated most every career decision that I've made in my life to date.
I hope not.
It's why I decided to go to law school at the age of 15, which is when I knew that I wanted to do that. It's why I became a Spanish-speaking victim witness advocate in the Lowell District Court before I went to law school. It's why in law school I worked with low-income families to help them with probate matters and housing court matters, and they couldn't afford an attorney. It's why when I got to Goodwin, I spent a lot of time doing pro bono work, working on behalf of a woman and her children to assist her through a difficult divorce, and representing an individual who at 16 years old committed 2 murders and was sentenced to life in prison without parole. It's why I became a prosecutor in Worcester. And it's why I wanted to work on behalf of victims of child exploitation there. And it is why I want this job. Finally, I believe that I possess the right temperament to be an effective Superior Court judge. I have spent years appearing before judges, some great and some less great. The great ones treat everyone in the courthouses with warmth and with respect. They greet the court officers each morning and they ask them about their families. They eat lunch with their clerks. They attend gatherings outside of the courthouse with the courthouse staff. They have patience with attorneys when they're running late or when they are not as prepared as they wanted to be. They have patience with litigants who oftentimes are navigating a system that's entirely foreign to them. They listen to everything. They make the parties feel heard no matter what the result. They're educated and they're thoughtful about issues that touch courtrooms every day, issues like mental health, issues involving addiction, and issues involving discrimination. They strive every day to strike the right balance between the need for rehabilitation and safe and effective reentry and the need to protect the public. They earn the respect of everyone in the courtrooms, and defense attorneys and prosecutors alike want to try cases in their courtrooms. Judges like that help restore faith in our criminal justice system. I think that's something we desperately need right now. That's the kind of judge that I admire, I have always admired, and that's the kind of judge that I will be if I'm fortunate enough to receive the confirmation. Members of the council, I don't want to be a Superior Court judge because I want to make Superior Court great. I want to be a Superior Court judge because I embrace the difference between the two. I want to preside in a place where I can have the most meaningful direct impact on my community. I want to preside in a place where the hallmark of the bench is collegiality and cooperation among the judges in order to achieve justice. And if I'm fortunate enough to be confirmed, if they sit on that bench, mine will be a courtroom where everyone feels respected and everyone feels heard. Thank you for your time this morning. I appreciate it, and I welcome any of your questions. And I'm just going to say goodbye to my husband because he's going to exit so that he can grab our children from school.
Good job, man.
Thank you.
Would he want us to continue the hearing so he can be here next meeting?
We want to get out of here before things get out.
He has the Zoom link already on his phone, so.
Well, thank you for your presentation. And now I will call on the councils if they have any questions for you. And so I'm just going to go on. Now we've been joined by Councilor Juvenville and Councilor Ianello. So let me go right down the line, okay? And I'll start with Councilor Ferrara.
Thank you, Madam Chairwoman. I just wanted, I don't have a lot. We talked in length. I want to say thank you. Service. I have 3 beautiful daughters, and it's quite an honor to have that. And I can tell that you're the kind of parents, you have kids that your mom and dad would to you. You have an incredible resume with civil, criminal, and did you prosecuted. You and I had a conversation just quickly. The whole court officer scandal that you're aware of. We talked about that.
Yes.
And then wanted to publicly ask you an opinion about the report and whether you think it should be, it was highly redacted. Whether or not you think that the whole report should be transparent and be public.
It's a good question. I'll say 2 things. I'm generally a fan of transparency. I think it's important for a public system. I don't know the reasoning behind why the report was, in this case, redacted, so it's hard for me to give you an answer, a yes or a no specifically. I don't really know more about that, but I am generally a fan of transparency, and I think it's important. I will say that I was able to read the report, and I got, despite the redactions, the nature of the issues was very apparent to me, even with the redactions. So.
Thank you for that. As a federal prosecutor, did you have the occasion to prosecute people for 42 1983 violations, essentially an assault and battery by a police officer, someone acting under the color of law?
I didn't personally have that kind of a case, but I did as a clerk when I first became a law clerk. Working for Judge Gordon, we had a 1983 trial, and that was my first experience with that.
you think that some of these things that have been documented in the court officer report could amount to a violation, criminal charge of 42/1983, people abusing people under the color of law?
I'm not going to rule it out, but I haven't taken the time that I would want to take to really look at the facts and the elements of that particular offense so that I could give you a more accurate answer. But it would be certainly something I would look at.
I am pleased that Judge Lock was put in place. I have full confidence to do the right thing. People call all the time and want to know why these people are still employed by the court. They're sitting home getting paid. People have paid. Do you have anything about that?
Yes, I'm surprised to hear it, although I don't know where, procedurally, I don't know kind of what comes next. I don't know whether or not there's a hearing or whether there'll be any process that they need to go through to determine whether they're able to keep their jobs. I don't know that I have enough information to say whether they should or shouldn't be in that position.
Thank you. People still, send me emails. They call me, they send me letters. Asking me to read them. I'm not going to interest in time, not going to read them today. But it's on the forefront of a lot of minds still out there. I'm confident that Judge Locke will see it through. I appreciate you applying. Thank you for your service to the United States and to the Commonwealth.
I appreciate that. I will say I've worked with a lot of court officers in my time, both in the state court and in the federal court. And I think they have an incredibly important job. And so I think it's an important issue, and I'm glad you raised it.
I absolutely adopt what you said. I've spent 30 years in law enforcement. I was a court officer for a long time as a sergeant, lieutenant, and they do an incredibly important job. And as a lawyer, the people that greet you will set the tone, right?
100% they do. Yes, they do.
Thank you. Thank you so much.
Thank you.
Thank you.
Thank you, Madam Chairwoman.
Thank you. Counselor Kennedy.
Still nervous?
A little bit.
I'm gonna ask you some questions.
I know.
And we went over them.
Oh, good. It's not going to make it any easier for me. It's okay.
We already went over them.
Okay.
Okay. I don't practice in the federal courts. Never see me in the federal court. And over the last 38 years, I've been a lawyer. I stuck my nose into the federal court or the C court here and there that don't belong there at all. Practice in the state courts, I practice in the Superior Court, and I practice in the district court. As time goes on, more in the district court, but still in the Superior Court. I wouldn't presume to consider applying for a federal judgeship for the simple reason that it's a different animal, right? What do you think of that? Do you think it's a different animal in the state court?
I do think it's a different animal. I don't think they're the same at all. But what I would tell you is that I think it's an animal that I would rather embrace, more so than
Have you ever appeared in the Superior Court in the United States?
I have never argued or tried a case in the Superior Court. I don't.
Have you been in the Superior Court courtroom?
I have in Worcester. There were times when one of my cases overlapped or had some connection to a Worcester or a district attorney's office case. And so I would go over to see what was happening in the event it impacted.
One of the things that I spoke to you about when you came to my office, and I told you didn't have to come, you would get into merits for not coming, but you wanted to, and I respect that. And one of the things I talked about was the transition from practitioners in the federal court, mostly U.S. attorneys in the federal court, to the Superior Court. And I have to tell you, I disagree with my friend Mr. Edinburgh in terms of how they fit. Even some of the people that he named, and I'm not going to talk about them specifically, but I did with you privately. I don't think that they fit so well into the Superior Court. Would you agree with me that some people don't make the transition as well as others, or do you know?
I don't know because I haven't been before them, but I would agree with you that temperament is really important. And I think I understand why you're.
There's a couple of people who he named that I don't think have the temperament. At least one of whom I voted for. Okay. I'll leave that there. But anyway, two things I find happen. One is that They come into the Superior Court, they're never interested in the District Court, so it's the Superior Court. But they come into the Superior Court and they try to run it like a federal court. And it doesn't work. Period. How are you gonna make that transition in terms of not trying to run it like a federal court? We don't have trial by appointment in state court. We're not told that we have to be there at 10:15 to do this motion. Or 10:15 to do this, that's to start this trial. You know, there's a room full of people and they're sending people out for motions to that session, to this session. It's much more chaotic. To a certain extent by design chaotic, but how are you gonna make that transition? Turn to him and ace loads, lawyers that are really busy.
Again, I'm going to embrace it. I agree with you. It's different. It's not the same as what you'll experience down at Moakley. But I guess the best way to say it is I know what I don't know, and I'm going to learn from the people around me, and I'm going to take cues from them. I'm not going to go into Superior Court thinking I somehow have a better way of doing things.
I find that people who come out of the federal court system, some of the people studying, are more interested in moving dockets than they are doing justice. Well, how are you gonna handle that? You're gonna have a lot of pressure to move these cases along. But especially with the backlog that we have in Judge Locke. Well, I was in the DA's office 38 years ago, was not in charge, and he said it's his mission in the 2 years he has left on the bench to clean up the dock. He's gonna be all over you, as is Judge Brigham.
I think it's always a balance, right, between those two things. You do have to keep things moving, or things will grind to a halt. Well, I think you can't, there has to be at least some attention paid to keeping things moving, but not at the expense of justice and fairness, never at the expense of that. So I think it's a constant balance. It is one that I had to deal with in a different context when I was in Boston as the chief and deputy chief of the criminal division. There were hundreds of things coming at me every week, and they could be a multitude of different things, and I had to move them along. But I also had to make sure that every decision that I made was a fair one and a just one, because there were often a lot of implications. So I'm used to that pace a little bit, and I'm used to having to make decisions.
I don't think you are. I don't think you've
Well,
seen it yet.
Then I'm excited to be there.
You remember the chaos of the Lowell District Court?
I do.
That's what you're walking
I
into.
know. And
that's very different than what you
you're
described.
right. But, you know, and I told you when we talked, I expected fully to leave law school and go back to the Lowell District Court because I liked that pace.
There was one U.S. attorney that he didn't mention, the judge, that did a great job in terms of his transition and became my good friend Morris Flynn, who many years ago was a U.S. attorney. People don't know that about him, wouldn't expect that. But he turned into a really compassionate person on the bench, on the recall on the South Shore now. Just a great judge. He was there when you were there. I hope that him and the other judge, who you know was there, Walker, as an example. They were in district court. That's a different animal than Superior too. He's somebody who did make the transition, as did Judge Lang. Great job. But the other issue that I wanted to raise has to do with sentencing. Okay. Think about telephone numbers in the federal court system. Do you think the sentencing guidelines in federal court are fair?
I think in many cases, they result in, the guideline ranges that result are far too high. That's what I think.
Okay, but you use them.
We do use them,
You
yes.
made recommendations that you thought were unfair.
No, I didn't. I don't believe that's the case. In many of my own cases, in cases that I supervised, I agreed after discussion with my office and with those above me to ask for sentences below the guidelines, when that was appropriate.
Okay, well, there were times I'm sure you were told, no, we have to stay within the guidelines.
That is true, yes.
So there were times when you had to make recommendations as a lawyer that you thought were unfair.
That I maybe wouldn't have made if I didn't have superiors or.
Superiors, I get that. We're gonna talk about that. Mine is at home right now.
Mine is.
But nonetheless, I mean, you're sitting there and you're looking at this poor defendant there. You think maybe shouldn't go to jail. And the guidelines are saying, I know you're talking months, but I'm gonna talk in years, because that's what we talk about. So, the guidelines say 4 years and 8 months. You don't think the person should be there. And you're in front of Judge Gordon, what's he gonna do when you make that recommendation, the person you put for?
I'll tell you what I've done in the past. This hasn't happened thankfully very often to me, because I have been able to persuade my superiors that a different sentence is appropriate. But the times when it's happened, I have been very transparent with the court, and I have said, I have to ask for the sentence, but I'm now going to tell you about all the mitigating factors that you should consider, Judge, when you're trying to decide what to do. Because I think that's the only appropriate way for me to balance those two
So you
things.
basically, you're making a recommendation and saying, just kidding, Judge?
No, I'm giving the judge all of the information so that he can make the fair and appropriate determination.
You were involved with probation cases, right? Okay, what was your role?
I was assigned to that case when I was a relatively young AUSA. I was about 3 years in, and I was assigned to be part of the trial team. So I investigated the case, and then I tried with 2 other assistant U.S. attorneys.
And you know the end result of that
I
case
do.
from the First Circuit?
I do.
Prosecutorial overreach,
Yes.
imaginary crime. They said there was no crime. They said it was distasteful, I think was the word they used. But there was no crime, that it was a crime made up by U.S. attorneys, right?
There was definitely language in the opinion to that effect.
Very strong language, wouldn't you say?
I would agree it was strong
Okay,
language.
so we got a couple of U.S. attorneys sitting there making up crimes. Right? I think racketeering was one of the charges,
It was.
fraud was one of the charges,
It was.
and a whole series of other charges, none of which had any legs to them, according to the First Circuit, right?
According to the First
All
Circuit.
made up.
I think the way they put it was that the government had not sufficiently proved several of the crimes at trial.
I read it a few minutes ago.
Yes, I'm not disagreeing with you. Yes, the First Circuit did not like the case and reversed the conviction.
They said there was no federal crime that fit the facts.
That's true.
I think that was the language, right?
That's true.
So we have, and I'm not defending some of the things that went on there. But how do we go from nothing to creating an imaginary crime that destroys lives? That's what happened. People are sitting there that were fairly well-respected people, attorneys and otherwise, other people, that, you know, they were waiting to see if they were going to jail. The pensions were suspended, or they all had to leave early and got significantly reduced pensions. They spent hundreds of thousands of dollars on legal fees on an imaginary crime.
I can say to you that at the time that I investigated that case, did some research and quite a bit of research regarding the law underlying the crimes that were charged. The government had a good faith basis to believe that there was a crime. I wouldn't have been a part of it. I can say that.
The First Circuit didn't agree with that.
They did not agree with that, and they.
I mean, they used some really strong language. They just didn't overturn these convictions. They used some very strong language condemning the whole case.
They did. I don't disagree with you on that. But I do believe
Were they wrong?
I respect their decision. They get to make that decision, and I respect it. They get to interpret the law, the mail fraud law, the state gratuities law, and I respect their decision, and that is the law going forward. For sure.
When you were there, were you involved in the decision to prosecute Shelley Joseph?
I was the deputy criminal chief, so I played a role in the approval process. I was not the person who made the decision.
Do you think the U.S. Attorney's Office in Boston should be prosecuting judges for actions they've taken in their courtroom?
I don't think any one of us, including myself as a prosecutor, is above the law. I will say that. I think that.
Okay. Well, the situation may not have been handled properly. Probably wasn't. I don't think it warranted a federal indictment.
The case is still pending. In
I understand that.
circuit, so I don't.
I get that. And you were part of the decision process. And I hope that the new administration and the new U.S. attorney takes another look at it. Because I think that a great injustice is being done in that case. And I think, very frankly, it was a political prosecution coming out of the Trump administration because it involved immigration. It's my view. I don't have any other questions for you. You answered most of them when you were in my office. I didn't, I'm fair. Everything I asked you, I told you I was gonna ask. So, I think you do have a very good background in terms of your experience, no question. I'm not sure it's a background that's an exact fit for what you're doing, but I think one thing that is very, very clear to me, which isn't true with everybody who came out of that office, you have a good time.
Thank you.
There's no question about that. I'm all set. Thank you, Madam Chair. Now you gotta watch out.
Thank you.
Thank you.
Now you gotta watch out.
Council Juvenile.
Thank you. So back to O'Brien. And I will disclose that Jack is a friend of mine and has been a friend of mine for a long, very long time. So basically, he got many calls from state legislatures to put somebody on as a job, right?
Those were part of the facts of the case, yes.
People called him and said, Johnny Smith's a good guy, can you give him a job?
Those were some of the facts of the case, more or less.
Yeah.
Those were some of the facts.
So what's the difference in that and you being here with a list of names on your application and people calling the councils to say, you're a good person, give her a job. What's the difference in that?
So the case itself, the case as charged by the government, was not a case trying to criminalize patronage. That was not the intent.
What was it trying to criminalize?
What was charged was fraud, racketeering, but the underlying offenses were fraud and bribery. And the fraud was.
You really think that was a racketeering case? Wasn't that overcharging? Racketeering?
I think that at the time we did it, there was a good faith basis that the elements were met by the facts. And I would not have, if I had felt that we couldn't meet the elements at that point in time, I would not have gone forward. I wouldn't have.
Maybe, Mr. Wyshak, in fact, I had a couple of people in the grand jury in that case. And you could have probably went upstairs and however you could do it, or go to Washington and talk to say, is this really a case that we should prosecute? I agree with my counselor friend, Terry Kennedy. This was about politics and making careers. Sorry.
I understand.
Okay.
I know. It was
Jack O'Brien had the right at the time to hire anybody he wanted without any committees to go to and talk to. He could have done it without any of that stuff, couldn't he? He had that power.
I think there was a hiring process in place, but.
Well, there was a process that was criticized. But he didn't have to have that process. He had the authority as commissioner to really hire anybody he wanted, if he wanted to. Don't you agree?
To be honest, I don't remember.
Okay.
I don't want to give the wrong answer. I
Okay.
don't remember.
So I take it you disagree with the appeals court?
I don't disagree with them. I respect their opinion, right? What I will
Well,
say is.
that's not answering the question. I respect all opinions of judges. I disagree with a lot of them, except Judge Hillman. I never disagree with him.
We don't go there.
I will say this, when we first looked at the case, the way the First Circuit construed the mail fraud statute, in their opinion, was not the way we looked at it when we first were looking at it. So I
Okay.
think that they.
The question is, do you agree with it or don't? Say yes or no answer.
Again, I'm gonna go back to,
No, you're not going to go back. This is a very simple question. I disagree with some judges' opinions a lot. I'm not the judge.
Right.
And if I was a judge, I know people would disagree with decisions I make. And when you're a judge, there's gonna be people that disagree with what you do, or motions you deny or allow or whatever. So I wanna hear you say an answer to this question. Do you agree with it or don't you? I get the sense you don't, but that's not anything I'm gonna hold against you.
No, I understand that.
Well, then answer the
With
question.
respect to the mail fraud piece,
No. If you agree with the appeals court, forget the wording they used. Do you agree with their decision or not?
legally, as a matter of law, I disagree with it. As a matter of law, I disagree with it.
Well, you know, I think sometimes prosecutors in the U.S. Attorney's Office and in state DA's offices too, in the AG's office, they bring indictments against people without considering the effect they have on those people. You know, we had a judge here who prosecuted Joe Bolero. You know who Joe Bolero was? And Judge Harrington gave, I think, the only directed verdict I've ever heard of in the federal system. Rare. I'll bet you can't cite one other than that.
I can't. Just thinking I can't.
And I asked that person, that chair, and Counselor Ionella asked him it too. Knowing what you know now, would you have still indicted Joe Bolero? And he said yes. And even after I think Counselor Ionella said, I'm going to ask you the same question, and if you say yes, I'm not voting for it. He said yes again. So let me ask you, knowing what you know now, hindsight, which is always 20/20, would you have still gone forward with that case like that now?
I don't know. And that's the honest, I thought about this. I have actually spent time thinking about this. I don't know the answer. I'd need to look at the First Circuit's opinion, and I need to go back to the evidence and see whether we can meet it.
You don't believe in answering the question.
No, I do. I don't know the answer.
So you're giving me blown. Come on.
The answer
Come on.
might be no,
Come on.
but I don't, I just,
Come
I would
on.
need
You
to
read
go back.
you read that thing. When that came
Of course I
out,
did.
you read that thing 5 times if you read it once.
I did. I absolutely
You
did.
know all about it.
I did. I absolutely.
And what you don't know, or and I hope you care about it, is the destruction that caused for O'Brien, Tavares, and Burke.
I do. And I
It
watched.
ruined their lives. Ruined them. They will never get over that, mentally and physically. You ruined their families' lives when you indict people like that. And I said that to the judge that sat here that did Bolero. I said, you got a letter with 200 lawyers asking you not to indict him. And I believe that was political too. Because I said to him, my opinion, if you had gotten a conviction, you would be down in Washington as the first or second attorney general in the United States, based on Joe Bolero's reputation. And I said, not only did his practice suffer tremendously, his health suffered, his relationship with his wife and his family members, he's never been the same since then. And neither has O'Brien, Tavares, or Burke. None. And I sometimes think the U.S. attorneys don't ever consider that. Don't ever consider that.
I'll tell you, because I've been on both sides. It's not always something you're thinking about the first thing on your mind when you're an assistant U.S. attorney. It's not. But I have been on the other side, and I have watched the exact same thing happen to a client of mine. And I do know.
One.
Yeah, one particular one, because that one, it was a similar case like an O'Brien type of a case where it went on for a very long time. And so I watched the progression that this man went through because of a federal indictment. So I do understand it. And I agree with you that as an assistant U.S. attorney, it's not always the first thing on your mind. I think it's important that it be on your mind.
And I understand that. I was a cop at one time, and I locked people up. And I look back upon it and I say, I probably shouldn't have locked some of those people. But you did it have the bosses think you were a good worker, you were producing, you got some publicity maybe, your career advancement maybe. And I think that goes on a lot in the U.S. Attorney's Office and the certain DA's offices. I think that. But now you're asking us to say, forget all that. I'm down the Superior Court. And I agree with Counselor Kennedy. There are some former U.S. attorneys that have been terrible judges. Terrible. Never a break and never consideration for those people. None. There's guidelines in the Superior Court. You going to use those guidelines?
They don't seem very useful to me, candidly.
Well, you were a product of guidelines in the federal court.
Yes,
And before they were discretionary, they were probably the most draconian weapon the U.S. attorney had to bludgeon people into cooperating, right?
they were very harsh.
And they ruined lives. I know one particular fellow from Boston who was a graduate of UMass. He started selling marijuana and it exploded for him. I mean, he had more money than he knew what to do with. Never hurt anybody in his life. He did 20 years sentence. That's what, 15% off that, whatever it comes to, maybe 18 and a half. In a federal institution in Texas for selling marijuana that's now legal. And I don't even know why guidelines are even mentioned in this state with the destruction they did to people in this country, in this Commonwealth. And I hope you do not ever even suggest guidelines in your courtroom. Legislature hasn't approved them. They're the only body that can define what a crime is and define the punishment. Judge Harrington in the federal court refused to do criminal cases, as he said, I'm not going to use those guidelines. I will sentence people the way they've been sentenced for hundreds of years, looking at the defendant's record, looking at the defendant's background, looking at the victims, looking at the crime. And he said it's worked for all those years, giving a judge discretion. And judges, I believe, should have discretion. I'm not a fan of mandatory sentences. They take discretion away from a judge. You said to us today, you're going to be fair as a judge, right?
Correct.
Okay. So somebody comes up before you, it's a 10-year minimum mandatory, and you say, this isn't right. I know that she's charged with that. It's not right. What are you going to do with that?
I'm gonna follow the law because
No,
it's the law,
I don't know what it means to follow the law.
apply the law and interpret it.
That's what judges do,
Correct.
except if you're on the appeals court or the SJC.
True.
Every other judge in this system applies the law, interprets the law as they see fit, right?
Correct.
So you can interpret that scenario I gave you in a different way.
So I'd have to look at the facts to see.
No, forget the facts. We're just saying, you've said it's not fair. You've come to that conclusion. This is a terrible sentence. The DA, come up here. Look, why did you, can't you do something with that? No. Not fair.
If I'm bound by the law, I'm going to.
No, you're not bound by the law.
Well, if there's a minimum mandatory,
You're not bound by it. There was a little judge in Worcester. Little Superior Court judge, he's this big. She faced that quandary. And she said, no. I'm going to sentence the person to 2 years in the house arrest. She got overturned, but she made her point. She didn't get fired. You can't be fired.
I understand.
But it took guts for that judge to do that. It took big guts.
I agree.
And that's what I want you to have.
I have guts. I don't
know. You got to convince me you got guts.
I have quite a lot of guts. But, you know, I have to look at it, but if there's not, I'm gonna, I am.
Forget looking at it.
Well, no, I.
It's not fair. You've made that determination already to yourself. So forget looking at anything.
But if the-
I've made the determination, this sentence is not fair. What do I do about it now? I told the counselors I was gonna be fair.
If the law requires me to impose the sentence, I will, but I will speak about it. And
Weak.
I don't
That's
think so.
weak.
I don't think it's weak. I think judges can.
It's getting led by the hook in the mouth like the fish.
I would speak about it. I would
Stand
speak
up.
out about it.
Be bold.
I would make. a
Make
bold
your
statement
point.
about
Let me ask you something. Do you think if every Superior Court judge in this Commonwealth did that, what would happen?
it. There might be a change in the law.
100% in 10 minutes. But it takes one to start it. It takes one to say, this sentence is not fair and I'm not putting my name on it. You're not getting fired. You're not fired. Nothing they can do to you. If you get the guts to do it.
I would certainly have the guts to speak out about it in a written opinion and also in court. And I do think that can make a difference. I've seen it happen. I've
I
seen
hope.
judges issue opinions.
I want you to be bold, for God's sake, here. You're gonna have power to put people in jail, take their freedom away. Speak up. Do something. So what? What's another judge gonna say? Hey, you're an asshole for doing that? So what? I'm not doing that. That is not fair and I'm not doing that. You wanna go to another judge, go, but I'm not doing it.
I will be bold.
I think you said, you have wanted to be a judge for a long time,
True.
a Superior Court judge?
Yes, the equivalent of. In my mind, I think I had trial court judge when I was 15 years old, 16. I was in a state, I volunteered for the state's attorney's office. That's what it was in my town.
Well,
I think it was
yeah,
really a
I mean,
district
but
court.
yeah, I guess I got a thing with, you spend, like Terry Kennedy said, you spend your time over there, now you want to be a judge over here. But you tried to be a magistrate 2012.
I did.
You were 36 years old.
I know. I knew I had no
Bold.
shot. I knew I had no shot, but I also knew at some point I wanted to be a judge in my life, and I thought, you know what, it's gonna help me to go through the process.
All right, they didn't give it to you. You weren't recommended. 14, you tried again.
I did. Again, for a magistrate position. I thought,
No. Massachusetts Superior Court in 2017.
still too young.
And then a U.S. District Court judge, 19.
That was a little different, I'll explain. I didn't actually apply for that position. I was asked to interview, and I did, because I didn't, it felt like an opportunity.
Yeah, but you could have said no.
I didn't want to turn
Everybody
down-
comes up here and says, I don't know how many people I meet in courthouses and they go, wow, I filed for a judgeship. The judges were asking me to file. I say, well, who? Well, I forget their names. Here we are, You wanted to be a judge, okay, I get that.
I have wanted to be a judge for a long time.
You were probably too young, though. Don't
I
get
was
it.
too young. I was told every time.
So. Well. The Superior Court judgeship is, one when you get it, unfortunately, you don't have much interaction with lawyers after that, other than being in the court. Sometimes they go in your lobby. It's not like the district court where you interact in a lot with lawyers. So it's a very lonely job in some ways. You're going to go to lobbies that look nothing like the beautiful lobby you had in the U.S. Attorney's Office or in Judge Young's courtroom or any of the other judges. If I was a judge, I would move into those lobbies and live there. That's how beautiful they are. But you're gonna be in courthouses sometimes with a small. Brockton has lobbies that bathrooms are bigger than, and the building is in need of repair. And you're just by yourself until a clerk comes in and says, hey, "Come on, we gotta use you." You're gonna be able to adapt to that.
I am. Yes. Not only adapt, but I think thrive.
So did I get a full answer on the O'Brien thing if you do it again?
I'll follow up on it.
Okay.
Good.
Okay. Maybe give me,
College scan.
maybe I would. Maybe you'll give that to Council Ryan. Because, I mean,
College scan.
oh, the college
Yeah,
scandal,
let's go there.
yeah.
Thank you,
You,
Council.
you worked on that?
I skipped over it.
Thank
I'll
you.
forgive it to Bob.
I appreciate it.
You worked on that?
I did.
Yeah.
I did. To
Here's,
clarify,
here's my scenario.
Worst of the worst, we said that, yeah.
What's the difference? What's the big difference in that? And I say this, if my daughter, I could get her into Harvard, I would do probably whatever I had to do to get her, right? That's how important it is to go to those schools.
Mhm.
I mean, you graduate from them, boy, you've got a good future. But I get the fact that they got them through some athletic thing that they had no part. Well, what's the difference really in that or John Smith that lives in Montana that graduated from Harvard and he's hit it big in some area and he's worth millions of dollars and he builds the beautiful pool at Harvard. I forget his name. My daughter used to swim there. It's like a palace inside. It's like you ever go inside
I've
of it?
not been to them.
The first time you walk in and you see those pools, you go, oh my God, look at the size of this thing. And he paid for that himself. So what's the difference in somebody doing that or giving $10 million endowment and getting a kid into school through that way? And that's done a lot.
It is done a lot. I agree.
What's really the difference? I mean, the wrapping is a little rough in one. The other one is glossed in some velvet, but it's putting money up to get your kid in school.
It is. For me, the difference is, in the college cases was the lies. So if you spend $10 million to buy the pool building at Harvard, you didn't lie to anybody about it. You just gave money and then your son submitted an application and got in, your daughter. In the college case, the parents that we charged, for the most part, there were false applications submitted with pictures of children that weren't their children.
Right.
And children who were alleged
I
to.
get all of that.
So it's different.
It wasn't pretty.
Different.
It wasn't pretty. But don't you think that Harvard had some duty to, I believe they must have some sort of an investigative process, and Councilor Ryan, the daughter is at Harvard, you may know, but there must be some sort of an investigation or, a dive into background. And you think Harvard had some duty there to kind of make sure of that?
I think it can be hard depending on the nature of the fraud that's going on. If the wool's being pulled over people's eyes, then can be hard to uncover until maybe someone like the U.S. Attorney's Office or.
Yeah, but when they did the applications, didn't they have on it that, I'm what was one of them? What was one of them?
Yeah, one of them was they rode crew.
Crew.
Reportedly rode crew.
Okay, so I got my application in and I'm going in, I got the crew thing going. Doesn't the vetting process, the people that are looking on, let's say, oh, it's probably a coach over there at the crew team. Hey, Sally Smith is coming, she said she's gonna be, did you vet her, coach? Did you go out and, no, I don't know anything about her.
I think the difficulty here was, at least in a lot of the instances, there was call them a corrupt insider, but there was someone inside who may have been the person who would have done that, but was in on it, so it wasn't. So I agree with you, in some situations, this might have been ferreted out. I think it's harder when there's someone on the inside who's helping it.
Well, that sounds to me it was a lot of good press for the U.S. Attorney's Office. Jail. All right. You, let me see here. You do have some You have some good witnesses here today
I do. They're
that
the
I
best.
respect very much. Vincent Bongiorni has sent a letter in from Springfield. Wonderful lawyer.
He is.
Somebody I
He's
respect
one of
very
my
much.
favorites.
And Judge Lang sent a wonderful letter. He is somebody that, well, he was a state prosecutor and then a federal prosecutor, but he's been wonderful on the bench. I hope you take after him.
I plan to. Thank
And
you.
not like, I won't name the few, but not like some. Okay?
I've spoken with him at length about this. And
Bold,
bold.
come on. Shake up the place, what it needs. Thank you very much.
Thank you, Counselor.
Thank you. All right, Councilor
Yeah.
Ianella.
Thank you very much. You know, whenever we have someone sitting in that seat who's been a prosecutor, I believe, and you've heard this statement before, once a prosecutor, always a prosecutor. Your thoughts on that?
I think that can be true and can be hard to overcome. I think I've been fortunate enough to be both a prosecutor and a defense attorney, and so I think that's helpful. And I'll say one other thing, maybe to add to once a prosecutor, always a prosecutor, even if there can be times when that's true. The other thing about being a prosecutor for a long time is you learn what bad prosecutors are. And that's actually really helpful, because at least for me, and I think most prosecutors, you don't have a lot of tolerance for it. And I think that can be actually very helpful on the bench. So maybe one small good thing about being a prosecutor for a long time is that you do learn that. And I have certainly seen that, and I think that's going to be a benefit to me.
You know, when Counselor Juvenile was asking you about the O'Brien case,
Yes.
maybe I should have, but I wasn't aware until today, your involvement. And it was a difficult question for you to answer, in my opinion. I mean, to me, the government made a mistake. They never should have prosecuted O'Brien and the other two folks. It's been a while since I've read that decision, but you're struggling with that. I mean, when he asked you, and I'll ask you the same thing. Well, let me even backtrack. We had a commutation here a couple of weeks ago. I don't know if you read the paper or read anything about it. But the prosecutor who tried that case, he said, you know what? It's been bugging me. It's been bothering me. I prosecuted that case and I made a mistake. I overcharged the defendant. I forget which defendant he was. But he had the courage and the conviction to say, you know what? I made a mistake. We all make mistakes. I make mistakes all the time. And unfortunately, that prosecutor is not with us anymore. He's passed away. Okay, the one who prosecuted the case. But he wrote a letter, you know, obviously years ago. But it bugged him. It bothered him. Same question to you. This O'Brien case. I don't get the feeling. I think you're trying to, with all due respect, that you're trying to dance around the question. Do you think the government and you made a mistake? You think you overcharged racketeering? I'm going to ask you, I don't do criminal work. What the hell is racketeering that he did? You can explain that in a second. But do you think you made a mistake in retrospect? Maybe O'Brien and the other folks? Or you don't think you made a mistake? Because I feel like I respect. Well, we all respect everything. You know, I respect so-and-so, but, you know, tell us what you really think.
I understand the criticisms of the case and I understand the First Circuit's decision. I don't look back and think I made a mistake. And I'll tell you why. Because I still look back and I can honestly say that when I looked at the evidence and I looked at the law, when we charged that case, we absolutely did have a good faith basis to believe that we were doing the right thing. So I don't think I made a mistake. I do think the First Circuit interpreted the law in a way that was differently than we did. And now, based on that, I don't know that we could have. I don't know. I'd really have to go back. I'm trying to answer as honestly as I can for you. I will tell you this. I've had cases like what you were describing where I think back and I think that was not fair. I'm not happy with that result. I have had those, and I've had those feelings. This case was just a little bit different.
And if O'Brien, well, I don't even know, did they get sent, they were found guilty and then was appealed, did they get, what did O'Brien get for a sentence?
I don't remember, but he didn't, I think the appeals court allowed the sentence to be
No,
stayed.
they did, yeah, they did, but what was the sentence?
I don't remember, I'm sorry.
But you know what's funny? Here's a guy, and I don't know O'Brien. Here's a guy, O'Brien, a ton of money he lost. And had a wife, and I think he had children. And then I see your husband. Where's he going right now? He's picking up his kids. And he gave you a big hug and a big kiss. O'Brien, if that appeals court didn't do the right thing, he wouldn't be able to have done what your husband just did to you. I mean, but I just want, in any of these cases, do you ever feel like temperament, character? What's this woman really like? That to me, we know your record. You went to Harvard, you got a great educational background. Your resume is spectacular. It's very impressive. But what are you really like? Can you, I mean, it's the impression that I get that you don't say like, oh, I'm not sure your husband's first name, but oh, Joe, whatever his name is. Yeah, Colin. Like, oh, I don't know. I can't, this is the worst vacation. It's bugging me. I don't get the sense that you're that type of person. I'm being honest with you.
No,
I'd like someone to say, because we all make mistakes, but do you ever feel that way after you've been a U.S. attorney for a long time?
I think almost every single case I have, I feel that way. I don't like getting up and asking for people to be put into jail. I don't. I don't like it at all. It's the worst part of my job as a prosecutor in some ways. I want to do justice. I want to protect victims. I want to protect the public, but I get no joy in watching a family sit behind a defendant and be ripped apart because this family member, no matter what they did, is now going to spend time away from their family. I know what it's going to do to their kids. What is it going to do to their kids? I think about it every single time, and I struggle with it and I wrestle with it. And there's no doubt, as I sit here today, that will be the hardest part of my job as a judge.
I get it, but I could see something like someone's convicted of murder, home invasion, drug trafficking. Yeah, send those people away. I get it. But again, I don't do criminal work. O'Brien, and I know this is not quite the facts. He got calls from politicians, hire this one, hire this one. He got no personal benefit out of it. There's no allegation, at least, again, I haven't read a decision in years, that he got money to hire these people. And whoa, he's going to jail. And then the First Circuit said, no crime. Do you remember the sentence that O'Brien got? I know it was stayed. Do you have any idea what it was?
I just don't remember.
Yeah, and I was asking,
I know they asked for something, but Young didn't give it. Young gave him a lenient sentence of like a year.
so you were asking for even more
Yeah.
than he
I
got.
did ask for more than he got, but I don't remember.
No, I got it, but
4, maybe 5.
5 years in jail.
Racketeering.
Racketeering. What is racketeering in specifically in this case? Because I have no idea. I think of the mafia, the mob. What's
I think that's
racketeering?
traditionally how the statute's used, but it can be just any organization that's being run like a criminal enterprise. So.
And what was the organization?
The probation department.
Because he got, and is this the gist of it, that this politician, this one, would call him up and say, hey, Jackie, hire Joe Schmo? Is that the gist of it? Not quite.
Those were certainly part of the facts. I think that the problem, or what really was the crux, I suppose, of the crimes, the crimes charged was that there was a hiring process in place, and I take Counselor Jubenville's point, maybe it didn't need to be in place, but it was. And they were supposed to, I believe, hire the most qualified candidate as part of it. And there was fixing of scores, let's say that, on the score sheets in order to make sure that those candidates receive jobs. That is my recollection without going back. So it was more than just that. But I take both of your points. And I take your point, I think in a lot of white collar offenses, this is kind of the way that it is. And I feel the same way in those cases. I feel honestly, I have the same feelings of it doesn't make me feel good, whether it's a drug trafficking case and there's someone who's been trafficking drugs or a violent crime, because you know what? The impact on that person's family is no different, whether it's a white collar offender or whether it's a drug offender. That family is still going home without a father or a mother or something. So I'm not sure that it matters what kind of a crime it is, but I can assure you it weighs heavily.
No, I get it. I've been on this council with a lot of different governors. Can I look you in the eye and say that everyone who sits in that chair is the most qualified? No, I can't say that. In my personal opinion, at least 75, 80% have sponsors. No different than what Jackie O'Brien. He had this rep and this rep. They have a sponsor. I'm not going to ask you who your sponsor. I would never do that. But 75, 80% have a sponsor. Is he or she who sits there the most qualified? No way. Are they qualified? Yes, they are. Everyone I've voted for over the years is definitely qualified. And I don't know if these folks in the probation department, if it was alleged that they were not, they might not have been the most qualified, was there allegations that they were not even qualified for any type of probation job, or that they sort of got ahead of the line?
I think it differed. In some cases, there were allegations that they weren't qualified, but it differed.
Well, they all had probation's the only job where you have to have a 4-year college degree.
Okay,
So they had to have that.
They had to have that.
And I think some working in a field similar.
I'm sorry, I don't want to get it wrong, and I don't remember because it was a while.
Yeah, I mean, again, it's been a long time, but I just think whether it's right or wrong, I'm not saying it's right, but it's the way the system works. I mean, look at the ambassador to this job. You think they get it on qualifications? You really want to look me in the eye and think ambassador to Rome or the Vatican or Japan? Are you kidding me? They get it because how much they contributed. I mean, do you have any doubt on that? Do you think, I mean, just read the papers. Oh, so-and-so contributed this one. This one was a bundler for this one. This one's here. This is the daughter or son of a famous politician. That's the way it is. So the O'Brien case does bug me. And the fact that you couldn't, well, let me ask this. Can you name a case that you prosecuted or you were assigned to, that you went to your superiors and said, you know what? I don't feel comfortable prosecuting this case because I think this person is innocent. What was that case, if at all? That you were assigned to, you said, put someone else on the case.
That hasn't happened to me. What has happened are cases that I was assigned to investigate and ultimately went to my superiors and said, we can't prove anything. We can't prove it here. We have targets, but it's just not there.
So there's not, how long have you been in the U.S. Attorney's Office?
14 years.
14 years.
Yes.
So you never had a case that you were assigned to where, like this gentleman on the commutation hearing who said he overcharged him. You don't have any cases in 14 years where you say, you know what, I overcharged the person there. Or you know what, I never should have recommended that sentence. It was too harsh. It's bugging me. Do you have any of those instances?
Yes, I do. Sentencing, I do, for sure. And on the charging side, because in the federal system, we tend to get the cases at the investigation stage and we can actually investigate it, it's a little more rare to get assigned a case that's already tied up in a bow. But on the sentencing side, I have had cases where I don't feel good about sentences that I have had to ask for because of mandatory minimums that were in place.
Well, that's a little different. And I mean, that's something you don't have a lot of discretion on. Yeah, that's a little different than I'm saying.
But the U.S. Attorney's Office can decide not to charge a mandatory minimum, right? We could, and unfortunately, wasn't always my call. It was usually a superior. But there were cases for sure where I had to charge a mandatory minimum, and that is what the person was sentenced to, and I didn't feel good about that.
You have very little civil experience. I do personal injury. I don't do criminal. I used to do criminal many, many years ago.
I have to go.
I'll talk to you. Yeah. What will happen? Let's assume you're confirmed by this body. How will you get up to speed with civil cases?
I have had some civil experience, and it's actually been good because more recently in my current job at a law firm, I have been doing some civil work. And then I did some civil work when I was a Goodwin proctor. So I've got some background in it, so that will help me because I won't be starting completely from scratch. But other than that, I'm gonna learn, I'm gonna dig in, which is what I usually do. And I'm gonna rely on my colleagues, who've had more experience. So when I come up on an issue that, I've done my research, I think I know, but I want to talk with someone who's done it 4 times or 10 times. I have no problem, and I certainly will rely on that.
When you worked at Goodwin Proctor, you said in the civil session, did you file motions for summary judgment?
I was an associate, so I wrote them. I would help write them.
Yeah, I would say in my experience that clearly, I don't know, well, it's not like I take a survey, but I'd say 80%, maybe even higher, of the Superior Court judges deny motions for summary judgment. In other words, let the jury decide. What's your gut feeling about summary judgments? I know we know the law says this, we know this, but you're out with your friends and says, hey, what do you think?
I think it's probably hard to come up with a case where there are no genuine issues of material fact. That's my bet.
Yeah, okay. Well, that's good. Let me ask this. Let's assume the perception in the street, you're confirmed that this judge is doing a lousy job. Number one, would you want to know that?
Absolutely.
And how would you want someone to convey that to you without you being there's some type of retribution? Like, how would you? No, you're doing a lousy job. You go, what do you think of that? Oh, she's terrible. Because we all hear it, good people, bad. How would you want someone to convey that to you? Because another judge is not going to do it. A colleague is not going to do that.
I would like to hear it from whomever thinks it. If there are lawyers who think it, and I would hope they'd be knowingly comfortable enough to approach me and talk to me about it. And I feel this way about my work now as a prosecutor. If there were specific examples they could give me, that would be very helpful, so that I can reflect on those and make a change in my behavior or demeanor or whatever it is that I might need to do.
A little harder than that, because let's assume 5 years from now says, oh, Judge Bell, oh, she's so tough on sentencing. And I see you on the street. Are you Judge Bell? I think I remember, I'm hearing the fact that you're really, for number one, even, I'm not going to give you a particular case because then you'd be thinking bad of the other attorney. So it's going to be hard, but you'd have no problem if someone came up to you.
I really wouldn't. I actually appreciate feedback about what I'm doing. I want to be the best judge I can be. And if there are ways that I can be better, I'm all ears.
Okay. You work for Goodwin Proctor, a lot of attorneys in that firm.
Yes.
You work for the U.S. Attorney's Office, a lot of attorneys, a lot of support staff. And now you got this one-person law firm, okay? You got a Kennedy or a Juneville, they're basically one-person law firm. And tell me what you're gonna be like if they need a continuance or they need more time to file an answer, whatever. Again, because the big law firms have this person, so many associates. What are you going to be in those situations like?
I think very understanding. I get that. I understand that in state court, people need to be in 7 places at one time, sometimes. I think in general, if you were to talk to people that I supervise in the U.S. Attorney's Office, they would tell you, I'm very understanding. They will send me sometimes prosecution memos that are 100 pages long the night before they're due, and I was supposed to get them 2 weeks. And I don't say anything. I just read it because we're all here to do a job. Everybody has difficult lives. They've got personal lives. You never know what's happening in someone's personal life. And so I think that's how I would be, understanding.
Can you give me an example where you would deny a motion for a continuance that's not agreed upon? Whether a civil case, well, we'll say a civil case, because criminal case is more complicated than maybe, whatever, we'll say in a civil case. Give me an example that you would deny a motion for continuance.
I can't think of one as I sit here.
Okay.
I just can't.
So if it's on for the 4th time and the prior judge said, okay, I'll grant you a motion for continuance, but I'm putting an order in here. This case is continued for da-da-da-da-da, no further continuances. That's Judge so-and-so, now it's in front of you.
I wouldn't feel bound by that. I would just want to listen to the parties and find out what was happening. And
I-
if there's any legitimate, if there's a reason for it, then I'm going to be understanding about it.
So the fact that it's 4 or 5, that's not like, oh, come on, I gotta move, because you're under pressure to move cases. You'd be okay with that.
I don't think, I would never put a limit because I just don't think you can predict what the situation is.
Because I asked someone this question, I don't know if Patrick remembers that. And I said, basically the same question, not quite the same. And I said, but actually the question was even, to me, it was a no-brainer question. I said, let's assume, your husband, okay, in the case, in one of the parties, the plaintiffs or the defense says, the lawyer says, I got to continue, the motion to continue. Oh, my husband, oh, was he so nice, 25th wedding anniversary. He's taking me to Bermuda in a week. It's a surprise. And the person sitting right there, I'm not going to tell you her name. No, it's been on and I wouldn't grant the continuance. I go, excuse me? No, I wouldn't grant it. The husband, he should know about his wife's schedule. Are you kidding me? My wife has no clue my schedule. So, I mean, that was like, you'd never do anything crazy like that.
No, and I will tell you that my mentor who's sitting behind me, maybe still, no, he's not there anymore. This very similar thing happened in the courtroom, very similar. It was an anniversary issue. Very quickly granted, so that, it's a Broadway show that they were going to need to go see. And I don't think I even opposed as on the other side, because how can you? No, I would be very understanding.
And my last question is, and I've asked this question in the past as well. Let's assume one of the attorneys up here votes against your confirmation. And you get through. And now a month, a year, whatever, down the road, that person or a member of his law firm, we're no good one practice here, we're all small, files a motion for you to recuse yourself. What would you do? Because obviously the fear is, you voted against this person, retribution. What would you do?
I wouldn't even want there to be the appearance of impropriety, so if there was really a concern, then,
That's why,
yeah, if there
someone
was
up here is
really a
filing.
concern, then I might agree to it. I need to look at the legal merits of the motion, obviously, but I understand.
Well, let's
the
assume you got
appearance.
full discretion. You're backing off again here.
I think it's I think it's important to know that I will always look at whatever the law is.
I go, but let's assume that it's up to you. You got full discretion. Are you going to allow that motion?
I would consider it because I don't want there to be an appearance of impropriety. Or
Okay,
appearance
I don't
of-
want to hop on it. It's my last question. You say you consider it.
I would.
But when you consider it, that means to me, you may allow the motion, you may deny the motion. You'll consider it.
I would want to speak with the parties and I'd want to probably explore a little more because.
Okay, well,
I don't think I-
do it. You can do it with me.
Sure.
In other words, I'd say, listen, I voted against you. Just don't feel comfortable. I don't feel comfortable going in front of you. I just don't. I mean, we don't have to get into a million facts. And you're going to say, oh, I'm fair. I look at the facts of the case. I didn't even remember that you voted against me or you. But yeah, sure. What are you going to do?
If the law allowed it and gave me complete discretion, and after trying to persuade you that I was going to be fair and impartial, it didn't work, then I would allow it.
I will tell you this. I've been on the council a few years. I don't ask the question a lot, but I shouldn't say a lot. I've asked it a number of times. And everyone has said, yeah, no problem. I recused myself.
I'm only equivocating because I don't know the law regarding recusal, but if the law allows me discretion and you're not comfortable, then I would allow it.
Yeah.
That's the only reason I'm doing this at all.
Yeah, I'm sorry I didn't get in touch with you. I was a family. We were away. So,
It's completely
yeah,
fine.
yeah,
Don't
I
worry.
just want to let you know
Nice
that.
to meet you here. I speak with you.
Yes,
Appreciate it.
I'm good. Thank you.
Thank you so much, Counselor. Counselor DePaula.
Thank you,
your
Counselor.
time, sir.
That's right.
Good afternoon.
Hi, how are you?
Good, how are you? So a lot of my colleagues have addressed a lot of issues that I share their perspective on. on Counselor Ionella's questions just now, so you did say that you don't want even the appearance of a conflict of any kind. So what if one of my colleagues or myself voted yes to affirm you, and opposing counsel said, I don't, I want to remove because I don't think I'm going to get a fair shake? What would you do then?
Again, I'd probably want to have a hearing and hear more about it. That's a little more difficult because
Because if I voted yes, I want you on the bench. Do you think that's logical?
well, it is, but I think the other thing
Do you think that do you think that's good for our system?
what is good for our system to have?
If Counselor X
Mhm.
votes yes on a judge, they probably would like to appear before that judge. Or they might vote yes because they're afraid they will appear before the judge. What do you think about that?
I think it could create difficult issues, potential, I suppose, issues. I can understand.
Because we don't want the appearance.
Because you don't want the appearance. I could see people, like, I guess I could see if you were to come before me, potentially thinking that. But
Do you think opposing counsel would think that as well?
I would hope not. I would hope not. I would hope that.
But in reality, do you think they do?
I think it wouldn't surprise me if it crossed their mind, but I would hope that my history and
They don't do
reputation
that.
on the bench would be one where enough people would have been before me and would have been able to say, this is a fair and impartial judge. You're going to get a fair shake.
Fair enough. And I want to jump on another point Counselor Ioannella was making. So I don't have a problem with prosecutors. My first mentors in law school were prosecutors at Suffolk. What I am concerned with is making sure we have a balance of perspectives on the bench. And right now we don't. We have a bench that's skewed towards prosecutors. You fall in the category of mostly prosecutorial experience, some defense experience. Is my concern justified? Do you think we should have a balance of those perspectives on the bench?
I do. I support it.
Why do you think that?
I think I think people who come from either different walks of life, it can be culturally, or it could just be different career paths, different backgrounds. They're going to come to the bench with different views on things, right? Because they're going to have had different experiences. And I think, I just think that adds to kind of the richness of the perspectives on the bench. I don't want to talk, if I'm going to go consult with some of my colleagues about a particularly difficult matter, I want to be able to talk to people who are coming at it from different perspectives and who may have new things to offer, or new ideas that maybe I hadn't thought of because I haven't shared their background. So I think that's really helpful.
And if a judge who has primarily prosecutorial experience did what Counselor Juveville was talking about, go against a mandatory minimum, for example, that would be quite a statement.
It's certainly, it's a statement.
And you wouldn't lose your job. And in fact, the public would be with you if we are to believe public polling, and the voters, because most of the counselors here feel that way, and we've all got elected. On your resume, you mentioned that you achieved a nearly 50% increase in productivity within the criminal division, which is good, and it speaks to managerial acumen. So what does that look like? What is a 50% increase in productivity in a prosecutor's office looks like?
It looks like, I suppose it looks like more people, more arrests or indictments. That's what it looks like.
Okay.
Mostly.
Okay, so increased arrests and indictments
Increased charging, yes.
is equatable to productivity.
It's one measure. I think there are probably other measures, but if you
Have indictments gone up in your time?
They did.
Okay. And have incarceration rates gone up, or are you incarcerating more people in your term?
I don't know if that's true. And that's not part of the productivity, at least as I was including it on my application.
Okay, I wouldn't think so. I just wanted to make sure. So sentencing guidelines have already been brought up, but in your application, you talked about some of the factors that would be part of your exercise of discretion. So you talked about including but not limited to age and background of defendant, nature of the offense, expert testimony if relevant and offered, statements of victims, addiction or mental health issues, issues of bias. And those are very similar to the mitigating and aggregating circumstances that the Superior Court sentencing guidelines, which are not mandatory, offer. So what does that look like? So if you are considering the age and background of the defendant, for example, what does that mean? What does that consideration look like as you're evaluating a decision?
So I guess starting with age, if I'm looking at an individual, it matters to me whether it's I'm dealing with a young person or I'm dealing with someone who's had a lot of life experience, right? We deal with this I've had to deal with this at the U.S. Attorney's Office as well. I think that people who are on the I'll call them young adults, early 20s, from 18 to early 20s. Number one, I think you have to consider the life that they have ahead of them and what is it going to do to charge them now, and potentially, especially if you're talking about being in the federal system, going to prison for some time. What is that going to look like for them when they get out? Is that basically a life sentence? I think you have to think about that. I think that young people are more impulsive. I think there's science behind this, that they don't necessarily know how or conduct themselves the same way that older people do. And I think you have to think about that when you're thinking about levels of criminal intent, whether or not it would make sense to charge someone.
But what about as a judge thinking about sentences?
For sentencing purposes, for me, one of the biggest considerations with respect to age would be what I just said, which is if I'm considering an incarcerative sentence for this person, this is a young person. What is that going to do to that person and the rest of that person's life? If it's a sentence where he's going to be, presumably getting out, how is that going to impact him? What are we going to do on the back end to make sure that he can reenter society, that he can be productive, that he can get a job, that he can get training, that he can resume his life the way that it was? Those are things that are going to matter to me.
You're going to Superior Court potentially, and in Superior Court, the defendants before you in criminal matters, if they're black or brown, they were double as likely to end up there as the white defendants, because in the initial charging phase, strike that, because when there's concurrent jurisdiction between Superior and District, you're twice as likely to end up in Superior if you're black or brown. Why do you think that is?
I can't explain it other than implicit bias in charging decisions, and potentially, before that, when individuals are being encountered by police. I don't know exactly why that is. I think that the Harvard study that I think you're referencing makes it clear that there is implicit bias. There's actual bias, certainly.
How can we prove bias, though? I don't mean to push back. I appreciate you raising the study, but does it prove bias? I mean, can I prove implicit bias?
I think it's very, very difficult. Well, I think what the study shows is there is bias. There is racial disparity.
Right. But is that the same as bias? There is disparity. We can look at the empirical data. And obviously there's contextual information that we'd love to have that we don't, because certain agencies don't gather, or in some cases they do gather but don't share. But do we know it's because of bias?
I mean, I think the study tried to account for a number of other factors that could have explained it. And after accounting for all of those factors, said those don't explain it.
Okay.
So this is what's left.
So a bias towards what, being harsher on black and brown defendants?
I think that's the import of the study, yes.
And so then when these folks end up in Superior Court, and the study, as perhaps you know, indicated that it was about 28 to 30 days, depending if you're black or Latino, that you're going to face a larger sentence than compared to a similarly situated white defendant. But in district court, there's almost no difference. It's all Superior Court, basically. And on certain charges around guns and weapons, it's 120 days, which is a long time. And I heard quoted today that we spend about 40 grand a year to lock someone up. That's outdated, really outdated. It's 90 grand according to the most recent numbers that came out for the last fiscal year. So why is that? Why is that? So the bias maybe gets them there. And why the sentencing disparities?
Again, I can't explain it other than I think what the study does show is that even trying to account for things like neighborhoods and socioeconomic status and things like that, there's still this disparity. And so I think the conclusion has to be that there is implicit bias in our system. And I think that the significance of the study for me is, as a judge, I need to understand that and know it. And I need to be aware of it every time I sentence.
So how does that factor? What does that look like?
I think in some ways knowledge is power, right? And so for me, I think a lot of people don't know that. And so just knowing it and being able to think about it and consider it as I think about what an appropriate sentence would be. And I think about the fact that, okay, this is the person in front of me now. How did they get here? How were they charged? I think you have to think about all those things and you have to weigh them in your sentencing decision. I think that's what that study says to me. It also says to me that we need more data about this. I think the study itself says that.
It does.
And I think as a judge, it's important to advocate that there be further study, that there be more data provided, and just to keep abreast of really the latest developments.
Like whether or not we're locking up more Black people?
Yes, and well, let's assume we were to be able to get a better set of data, and it changed the statistics, and they were worse than what we're seeing right now. As a judge, I think it would be, I need to know that, right? And I need to be on top of it, and it needs to be something I'm thinking about every time I sentence them. I think it's true for prosecutors too, in terms of when they charge people.
Okay. That's all I have for you. Thank you for your time.
Thank you, Counselor. I just wanted to go back about my colleague, Mr. Iannello, and he and Councilor Juvenville were thorough about the O'Brien case. So I don't want to dig that all up. And I just want to just say, we'll never stop it. We'll never stop it. Not by this case, not by anything. And I've been here 22 years and I've seen it all on every level. I saw the time when Acting Governor Swift appointed her chief legal counsel to the Boston Housing Court. He only had been on maybe 3 months. But his position as our legal counsel here is to interview the nominees and recommend to the governor after the J&C interviews. There were 3 qualified applicants who had worked in housing court their whole legal profession. Her legal counsel had never been in a housing court, and they violated a statute because in those days you had to live I do a lot of research. You have to live 70 miles from the Boston court, and he lived in the western part of the state. He had just interviewed qualified people, and one of them that he rejected, and then he applied, gave his application half hour before the deadline. He is head of the housing courts, Mr. Sullivan. Okay. I found out that he was one of the 3 that was rejected. And just outstanding. And I thank Governor Romney for appointing him when he reapplied. That's why I say to people, reapply, because politics gets in the way a lot of times. And I'll tell you, he is the best outstanding judge. So I've seen it all on all levels. So this O'Brien case isn't going to change anything. I've seen it. It's here. It's everywhere. So I just want to tell you that it is, it bothers me on all of these levels that there are people that shouldn't be there. They shouldn't be judges. They shouldn't be in these positions. But I can't change it. And that's unfortunately the society that we live by. So having put that aside, let's get to you. Now, first of all, you went before the Judicial Nominating Commission. And I always tell people who don't know, the Judicial Nominating Commission are 21 lawyers in the state of Massachusetts that are chosen chosen to recommend judges and clerk magistrates to him. Can you imagine having that authority? I don't. I only vote on one person. I don't know how many people have even applied. Tell us of those 21 people. How many of the attorneys were at your hearing, and when was it?
My hearing was a while ago. It was approximately 4 to 5 years ago.
So you didn't have to go up again?
No.
Okay.
So I applied, I think, one of the counselors indicated. that for the
Okay,
first
so
time-
that's a little different. I don't know whether it was the same JNC as now. I don't
I
know.
don't know that either, if it was the same then, but when I first applied, I went through, I want to say it was approximately.
Do you
4 or
remember how
5
many
years
people
ago.
were there?
There was I want to say there were about 10 people in the room and others on the phone.
That's the norm.
So.
Can you
that's my
imagine
memory.
11 people vote, whether they vote no or yes, never saw the nominee, never talked to them, never called them. So I'm saying it now for the public. It goes nowhere. It doesn't change. I've never seen a JNC operate this way. We should have 21 people there. That's an awesome responsibility to give a lifetime position. Okay, having got that off my chest. Okay. Now, I think of federal, it's a little different. So what is the learning curve that you will have to go to the Superior Court in Massachusetts?
I think there are some similarities. A lot of the constitutional principles are very similar, some differences for sure. Some of the rules of evidence are similar. So there will be, I think I have a good basis of knowledge to help me transition, but I have a learning curve for sure. As I think Counselor Inell pointed out, a little more on the civil side than I will on the criminal side. But even on the criminal side, I'm going to need to learn the nuances of the elements of each of the offenses. They may differ a little than federal law. Some of the rules of evidence are going to be different. So I am going to have a learning curve. I embrace it. When I became a prosecutor, I had never really been in a courtroom, and within 3 months I was trying a case. So I think I excel at learning new things. I enjoy it.
Yeah.
And I will embrace it here. I'll lean on my colleagues who I know will be great assets to me in that regard.
So what do you feel that you can bring to the Mass Court from the federal court to the Superior Court?
I think there are some things about the federal court that are some of the programs in particular that the federal court has had the resources, I think, to be able to start that have been, I think. Really,
Excuse me, you have said that we do lack resources in the Superior
there are
Court.
more- I think there are
Yeah,
more
that would
resources
help
in
the
the federal
judges.
for sure than there are
Yeah.
in the state Superior Court.
Yeah.
But there are some programs. There's a program in particular called RISE, which is really a terrific program. It's not a diversion program. It's where an individual is charged, will plead guilty, but then has a year to become involved in a number of different rehabilitative programs. If there's mental health issues, if there's addiction issues, person will go through treatment for those things, parenting, restorative justice, which is really a key part of it, interactive journaling, so that they can process what they've been through in their life and what they've gone through with respect to this offense. But it's a great program. The state, I think, has things that are similar to it. I've seen them, but not quite as comprehensive. I've seen it work really well on the federal side. And so, I would be open to bringing ideas like that to trying to help start programs like that or be a part of it with other judges. So there are some things from the federal court that I think, some ideas and some programs that they have that I think I could bring over.
Okay. And I do want to thank you for all the time you afforded me at the diner. And you had great witnesses. And I like to see witnesses who really know you, and they know you professionally and personally. I have been here long enough to see a witness come, and I'll ask, well, what experience have you seen this nominee in court? Oh, I saw him once. Or you give, I don't need that. I really need authentic people. So I do want to go back to your beginnings. When you first started and you represented someone with a life sentence without parole, right out of the gate. Tell us about that. Tell us. I'm the only one left here. Tell me.
This was while I was at Goodwin Proctor, and it was one of the pro bono projects I was fortunate enough to work on. A partner at Goodwin Proctor who was really dedicated and devoted to this individual and worked on the case for years, even after I left, brought me in to help with the case. The case involved an individual who was 16 years old when he was charged with committing 2 murders in the North End. And he was later convicted, and he was sentenced to, I think it was 2 terms of life imprisonment without parole. And he was, again, 16 and a half at the time when he those offenses. He went through motions for a new trial. He went through a new trial, was convicted again. And then so was an adult by the time I started working on the case. My role was to help. We were filing a federal habeas petition in the federal district court to see if we could get him relief based on ineffective assistance of his trial and appellate counsel at the state level. And so I worked on that piece of the case. It stayed in the federal district court for almost a decade, but eventually it was all denied. At this point, I had moved on, but 2015, I believe, the SJC decided I'm going to butcher this name, but the Dianchenko decision, which said that juveniles can be sentenced for murder to life in prison without parole. And so this individual was resentenced a few years later to just life with the possibility of parole. And then 4 years after that was eventually granted parole.
Now tell me, what is your opinion on the juvenile court? You're not going to juvenile court, but what is your opinion of increasing the age for the people in Superior Court?
You know, I don't want to avoid the question, but you know, I don't know enough to be able to tell you whether we should or shouldn't. I'd want to talk, frankly, with some juvenile court judges who deal with this every day. And I'd want to see, based on what they see in and out every day, what they thought about that before I formed just an opinion about it.
Yeah, I'm very opinionated, as people know. I am not for increasing the age. We already did it once. I think that's enough. And what we're seeing is a lot of juvenile crime and murders, you know, really. So I'm very pleased that you speak Spanish. I think that's such an asset that we don't have. You were the only one in your courthouse that spoke Spanish. And I was impressed that you helped a lot of the Spanish women and who were getting restraining orders. Now, I want to tell you, I believe strongly that it's not always the way it should be, because there are men that are accused wrongfully. We know that. But I know there are a lot of women that really have nowhere to go, and I appreciate that. And I have to tell you, that's the reason I'm here. That's why I ran, because of restraining order. I had a friend who was in a very dangerous relationship with this man. I don't know why she ever got involved with him. He was not a good person. He wasn't even good looking, to be honest. So he became very violent and was physically abusive constantly. She'd gone to court 7 times, hoping that the judge would give her some relief. The 8th time that she went, my late husband, who was a firefighter, he had a police officer friend. He had him go to court with her. And he said to the judge, give him a $200,000 bail. She fears for her life. He gave him a $200 bail. He turned to my friend in fear. She paid it. And our police officer friend said he was out the door before the boyfriend. And the judge said to my friend, you are wasting my time. You're wasting the court's time. She was dead 2 weeks later. He killed her. And I'll be honest with you, I had no idea how governors got their job. I thought they were appointed. I had no involvement. I didn't know. So I looked into it and I found out the governor's council approved. And I looked into the responsibilities and I said, I can do that. And so 209As are very important to me. We don't have a lot of nominees coming before us having a lot of experience in 209As. So I just want to tell you that I really appreciate that experience. And so having said that, did you feel that, you know, they don't know where to go, these women, and you said they were naive girls and everything. So what, I don't know how we can really protect them, can we? Really, you know?
You know, I think having victim witness advocates in the courts is incredibly helpful because it's sometimes people just need someone to guide them through, to take them over to the clerk's office and help them fill out the form. They just need somebody there with them. They don't always have family members. They don't always have friends. So I think that's a wonderful, it's a wonderful tool that the system offers.
Well, you know, I'll be honest, I like to see people older, but your legal experience, you've had more experience in different areas than people who have practiced 25 years. And the thing that I'm concerned about today, and we don't hear it from nominees, and it's all done with this whole new way of these perpetrators reaching young girls through the internet. And we hear it all the time. 45-year-old man sends a picture of a 17-year-old handsome man. And this naive girl thinks she's meeting this boy. And just this week in the Sunday Globe, there was an article about this predator. And he only got 20 years, which to me is egregious. And he has multiple former criminal acts concerning the same thing. He drugged, he raped a 13-year-old girl and watched her die. 20 years. That to me is a life sentence without parole. That merits it. I'm concerned about this kind of sentencing. We had 2 commutations today. Unjust. Those 2 men were good people, and they got life in prison without parole. And again, because there wasn't one black juror. So everything has a reason that it happens, I guess. So, you know, so I'm concerned about that, and you've had a lot of cases, so I want you to talk about that. And do you have any ideas what we can do to prevent it? I don't know how. And tell us, you had one that I think was in different states and everything, right?
I did.
Okay,
Yes.
why don't, I'm gonna stop talking. You tell me about those cases because I know, but I want the public to know.
Absolutely. I'll tell you one thing I do think we can do, because that's where you ended, I think. And one of the things that I used to do as an assistant U.S. attorney is talk at various schools, some even elementary schools, even to kids as young as 3rd and 4th grade. But which it's scary to think that you need to do that, but I think it's important, and just to educate them on internet safety and, you know, what they need to be looking out for. I think that's a really important step to be doing for our youth, because I think it's hard for parents sometimes. And so if they're getting it in the schools as well, and if they're getting it from the perspective of people who've seen, unfortunately, what exists out there, that's a really useful tool. But I've had a lot of cases involving child exploitation, some involving hands-on contact offenses and some involving on the internet side. So enticing a minor or distributing child pornography. One of the cases that you and I talked a little bit about when we met, it was a case involving an individual who was almost 40 years old. And he was preying on young girls between the ages of 13 and 16 online in different states.
Was that Ritter?
It was Derek Ritter. Derek Ritter. He would pose as a 17-year-old boy. He had a photo of himself. And so when these women and these girls really would meet him online, they thought that they were getting into a relationship with a 17-year-old boy. And this was a process that took months and months and months. So he would groom them. I don't think I knew this at the time, but once I met the women, these were young, I mean, they were girls who had very low self-esteem. Some of them had had very difficult childhoods to that date. And so they were very impressionable and probably looking for that attention on the internet. So he took advantage of that. And it ended up getting, we would get close enough to each of them that he finally would reveal his true self to them. And then he would travel all over the country to meet them. And he would pick them up and take them to a motel and engage in sexual acts with them. And we eventually were able to, by identifying one of the victims, we were able to identify this network of girls that he'd been doing this to for years and years. And it was an awful case, but it was also one of the cases I'm the most proud of. One of the cases that reminded me of why I do my job. Because we were able to stop it. We were able to, he was able to be prosecuted. And I think more importantly, some of the young girls were able to take part in it and were able to come forward and were able to have their stories heard. Some of them testified. And I think that was empowering for them. And I think it was important for them. And my hope is that they're stronger because of this and that.
I am so sorry that I'm the only counselor sitting here at this hearing that is hearing about that, because we don't hear about this subject. And we should be telling the JNC to be looking for people who have this experience. This is so prevalent in our society. And it to me, it's frightening to think of, some girl who, who's just taken in by someone saying all these wonderful things about her and everything. And it's involved in pornography, and they have her posing, and it's so egregious. I can't even talk about some of the things. But so how many cases would you say you've been involved? How many years have you been involved in this type of?
I started doing child exploitation cases when I first got to the U.S. Attorney's Office in 2008, and I continued to do them all the way up through at least 2019, 2020. So it's always been a part of my work. It was the biggest part of my work probably in the first 5 years.
So when you do find someone and he's guilty, what has been the sentence that the person has got?
It really ranges. There are some crimes that come with minimum mandatory sentences for this kind of behavior in federal court. Sometimes 5 years, sometimes 10, as much as 15 in some cases. I can't tell you what the highest sentence or the lowest sentence was. It really is a range, and it depends very much on the conduct, the number of victims, how egregious it is, how long it's been happening.
Is there anything that can be done? I mean, you as a judge or being on a committee or whatever, is there anything that can be done to stop it, to, the way it's used online and everything? And
I wish I
internet?
had an easy answer. I go back to education, though. I really think it's so important that we're teaching our children, even at a really young age, at an age that I think most people would think I don't have to talk to my children about that now. I think it's really important that we as a society are doing that, not just parents, but that the schools are, because I think that's probably I'm not sure there's going to be anything that just ends it. So
It's so upsetting, and yet I don't know, there's no regulation for internet or online, and everybody's addicted. And I live across from a middle school, and they're all coming out, looking at their phones, no one's talking to each other. So I don't know how we can control it, but there's got to be some regulation. There has to be to try to stop it anyway, you know? Now, you were very proud of, now I'm going to ask you what the most rewarding case is, and I don't know whether, I'm guessing, was it Richard Lane? Was that, or is there something, why don't you tell me, what is the most rewarding case you had?
I think most of my cases have been very rewarding in some way or another. The Derek Ritter case was probably one of my most rewarding cases because
You found him innocent.
well, that was the individual that I was just talking about in the child exploitation
Okay.
case. That was particularly rewarding because I think of the interaction I was able to have with the victims in the case and the role they were able to play. By the end of it, I really felt like I had made a difference in their lives, and that's why I did that job. And so that's probably one of my.
I mean, that was a big profile case. You're talking about a pharmaceutical company, and so you really have, like I said, for your age and for your legal experience, you're bringing a lot to us that we haven't seen before. White collar crime, all of this, So tell me about the Victims' Rights Law Center. What do you do? What is involved?
They're in Boston, and so when I left the U.S. Attorney's Office last year and I started working at Manat, which is a law firm, they have an office in Boston. I wanted to get involved in pro bono work. And one of the Manat partners with the Victims' Rights Law Center in Boston. And this was my first experience with them. They've been wonderful. They help women and men, anyone, I think, who is dealing with, wants to get a restraining order, needs help with that, or has been a victim of sexual assault and needs assistance with maybe a criminal case that's happening in court, maybe obtaining an order so that their medical records don't need to be disclosed, or getting a restraining order or a harassment prevention order. So they help with those kinds of things. And I've taken some cases since I've started from them so that I can, just because it's something that I feel good about doing.
You're asked to name the 4 attributes you think should be in a judge, and you hit it: compassion and respect for others. And that to me is the key, I think the most rewarding to me is that they have mentors now for judges. And boy, did we need them. And it's working, because I got calls from some young judges who were really rude and awful, and they're getting better. So I don't believe in learning on the job, but unfortunately, sometimes this council approves people that shouldn't be up there. Okay? Okay. Yeah. So enough about that. But I like what you said, that you're not going to be a government judge. I think coming from the federal side, people would think that. Now talk about that, how you're not a government judge.
I mean, I think I'm going to be fair and objective to everyone who comes before me. I think part of what will help me in that is that I have been on both sides. I've spent time as a defense attorney, and so I understand what it means to have a client and to represent them. And I understand what it looks like to have someone go through the criminal justice system on that side of things. And I know what it's like on the government side. And as I think I mentioned earlier, I know how the government is supposed to act and conduct themselves, and I know how they're not. And so my hope is that that breadth of experience is going to help me to be an absolutely fair and impartial judge on the bench, not a government judge, not a defense judge, just a fair and impartial judge.
It was said here by a counselor that once a prosecutor, always a prosecutor. I've been here 22 years, and I have seen the judges that I have voted on that were a prosecutor. I don't think that's true. I think they've been very fair, and I like to see someone from there too. What was your most disappointing outcome of a case? Can you think of one?
You know what, it was, I had a case once, an investigation, where, elderly individuals were being taken advantage of. They were in nursing homes, and some of them were starting to suffer from dementia, and there was an individual who allegedly, and, it's absolutely allegedly, was taking advantage of them in order to take their money, in essence. And the stories were incredibly heartbreaking, for these individuals. By the time I got the case and started to look at it and investigate it, some of the victims were dead. And some had reached stages of dementia where it was very difficult to speak with them or to get information from them. I investigated that case and really did everything I could to try to get some measure of justice for these individuals, but was not able to come up with enough evidence to meet my ethical obligations and my standards, and we just couldn't do anything. And that, it sticks with me. It was a while ago. It sticks with me though, because these particular victims were some of the absolutely most vulnerable, and there just wasn't anything that we could do under the law.
I'm looking for your writings. I was very impressed. I don't know where they are now, but there was quite a lot of articles that you've written. Oh, here it is. This is a few of them. The government's new strategy to counter corruption, what you need to know. OFAC, what is that, OFAC? I didn't know
Office
that.
of Foreign Asset Control.
Speaks again on ransomware, mature cybersecurity programs are important. Disclosure of investigations, whether and when for public companies. The False Claims Act in universities from fraud to compliance. And then you help to prepare and draft market timing and late trading, criminalization or regulation, white collar crime 2004, late trading and market timing, the review of securities and commodities regulation. That's quite impressive. We don't always have published writings in the resume. So tell us about which one was most important to you in the outcome of that article.
Well, I'll tell you the most recent one. I think that's probably maybe the easiest. Some of those go back to my days at Goodwin Procter. And a lot of them, just to give some context, maybe were areas of the law that I was looking at that particular time in my career. The latest one that I have there was on the government's role in countering corruption. Recently, the White House issued a new strategy for countering corruption, not only in the United States, but internationally, and really detailed several of the methods that the government intends to use going forward to try to cut down on corruption. And so the point of that writing was to not only synthesize what the strategy was going to be, but to try to help companies who were looking at their compliance programs, and maybe they can now knowing what the government's looking to do, can take a more reflective look at them to decide, is there something more we need to do here to make sure that we are protected?
Yeah. Well, I regret that I'm the only one to hear a lot of the questions that I've asked you, but I do want to put on the record the two letters that we received. Vincent Bongiorni. Did I pronounce that right?
You did.
Wow.
That was lovely.
My mother would be so proud. My mother was a Danucci. Honorable counselors, I am writing this letter to you in support of a judicial nominee, Karin Bell. In the past, I have had the pleasure of appearing personally in support of a number of individuals who have been nominated for judicial positions. Unfortunately, I will be out of the country when the council takes up this nomination and unable to appear. In lieu of a personal appearance, please accept this written expression of my support with respect to Ms. Bell's nomination. I have practiced law since 1974 and have had the opportunity to have tried a number of cases in the state and federal courts in front of a wide variety of jurists. Most of the trial lawyers I know, with a similar amount of trial experience, agree that there are several qualities that any nominee should possess in order to be accepted for this position. First and foremost, they should have a life outside the courtroom. Secondly, they should also have actual trial experience and have worked for a living in the practice of law, and at last but not least, understand they are impartial referees, not advocates. Karin Bell checks all of these boxes. I have had personal experience in trying cases with her when she was a trial attorney in the United States Attorney's Office. I always found her to be prepared, professional, a zealous advocate on behalf of the government, but also collegiate and willing to listen to opposing views. I'm aware that members of the criminal defense bar have complained when nominees are chosen, whose only legal experience had been limited to employment as a prosecutor. And I have always shared the same concerns. In the end, however, nominees need to be judged individually on character and merit. Karin has worked both as a AUSA in the public sector, as well as a respected litigator in the private sector. And perhaps most importantly, all the while being a great mother to 3 children at the same time. My personal experiences with Karin Bell lead me to urge this body to approve her nomination to be an Associate Justice to our Superior Court. In my opinion, she possesses those qualities that would make her an asset to the Superior Court bench. Very truly yours, Vincent A. Bajoni. The other letter is from James Lang. Dear Governor's Counselor, I write in support of the nomination by Governor Charles Baker of Karin Bell as an Associate Justice of the Superior Court. I am now in my 10th year as a judge on that very same court. No. But before that, Karin and I were colleagues for about 5 years at the U.S. Attorney's Office in Boston. Although I never worked in the same unit as Karin, nor served as her direct supervisor, soon as after she joined the office, I became chief of the criminal division, a position to which Karin eventually ascended herself some years after my departure. In that capacity, it was my responsibility to keep abreast of the work of all AUSAs as within the division and their reputation among their colleagues, the defense bar, the judges before whom they appeared. From the very onset of her career as a federal prosecutor, Karin distinguished herself by the quality of her work, her impressive advocacy skills, her excellent and incisive judgment, and her collegiality and temperament. In short, she was an outstanding AUSA in all respects. In the years since we parted company as colleagues, Karin's move up through the supervisor ranks of the U.S. Attorney's Office is a testament to the fact that many others shared my exceedingly high opinion of Karin. As someone who came to the Superior Court bench with a professional background that was very similar to Karin's in many respects, I think I have a special understanding of the challenges that she will face in transitioning to this job. I hope then that my words may have special resonance. I have complete confidence that Karin will be a truly exceptional judge. She will be prepared, knowledgeable, and assiduously fair to all parties. Above all, she will be patient, courteous, and respectful to all who come before her and all of the members of the trial court staff with whom she will work. I also have confidence that Karen understands the different demands on judges and practitioners in Superior Court as compared to federal court, given the much higher caseloads in this forum. I have no doubt that she will not only adapt to the decidedly different litigation culture in the Superior Court, rather than expecting others to adapt to her imposition of federal court practices, but that she will wholeheartedly welcome doing so. Like me, when I was a federal prosecutor, Karen spent the bulk of her career as a AUSA handling cases, they're of a kind, with those we say day in and day out on Superior Court docket. She did so, I believe, because just like me, she also felt that the nature of support court practice and the types of cases done in this court suited her best. So I know that Karen will embrace the substance and culture of the Superior Court. I also know that she will make it her goal to be the kind of judge that every litigator, civil or criminal, hopes for. I would be remiss if I did not speak at least briefly about Karen's personal qualities, which I have only glancingly touched on above. She is a wonderful person of surpassing decency. Karen is gracious and friendly, and she has a great and self-depreciating sense of humor. Although she takes her work very seriously, she does not do so with herself. Outside of work, Karen has a rich and rewarding family life. In sum, she is a well-rounded person who has her priorities straight. I respectfully urge you to confirm Karen's nomination to the Superior Court. I have no doubt that if you see fit to do so, Karen will be a selfless and exemplary colleague, and that she will serve the public with great fairness and distinction. Very truly yours, James Law. What a beautiful letter. So those are the letters. Is there anything else that you would like to say that we haven't covered? I just think that what I found, and you won't believe this, that I like the best, you don't want anything but Superior Court. And you said it because that's where you belong. And when we met for all those hours, I asked you about that. And you said, what I hear meeting with so many nominees for district court, I think of so many of them. Judge Pomeroy, he's just an example. And he said, I don't want to be in any other court but district court. That's the people's court. And you said about the Superior Court, now you tell me what you told me.
I think of district courts as the community courts, and but as between the two, it's probably more important that someone who's going to be in the district court has practiced in that court, and they know that court, and they know all the little idiosyncrasies of that court. And when I reflect on my skill set, what I've done over my 20-year career, the skills that I've developed, they're skills that I can give to the Superior Court that will be more beneficial to the Superior Court than they will to what I think the district court is.
And you know what? And I know what I've learned being here, most important to have a writing ability. And you do. And you told me you love writing. And it obviously, your writing here went on for pages, your last writing. So I think that's very important. I mean, we had a judge that this council voted for to the Superior Court. Too much writing. He got them to put him back to the district court. I think his name was Coun. I didn't vote for him. But anyway, that's okay. But I'll tell you, I am very impressed, and I thank you for all the time that you afforded me. And I'm just sorry that I can't hear this, because I really mean it. We have to see something about this pornography and sexual abuse of they're children. They're children, and they're so vulnerable. And I don't know what the solution is, but I'm glad you're there. And I will be very happy next week to put your name in nomination, and we will be voting next week. So
Thank you.
I'm going to adjourn me.
Thank you.
Thank you so much. Thank you for staying.